Well, it's Jon Bolton and Nathan Thornberry, the inspectigator from Orlando, Florida, multi-inspector firm owner, thought leader, uh, big time presenter at the Inspection Super Conference, doing a couple of courses, I believe. No, just one. You're doing three. Okay,
Yeah,
so
we've got
um,
three.
you're going to have to name them because I knew what one of them was. We have an advanced pool course that is to die for. Everybody loves that one. You're doing that again, I hope.
Yeah, we're doing the pool, and that has absolutely been hands down our very best. We get some really good feedback, and yeah, so we're doing that again. If you haven't been there, you really want to take this class. It's way more than just doing pools. We go into developing multiple streams of income and a lot of other stuff than just pool inspections. It's pretty good. We've got some advanced mechanical and then another one on the business side.
Excellent.
Yeah.
Well, the advanced pool and advanced mechanical, the business side stuff, inspectors should pay way more attention to than they do. And at our conferences, the courses are very well attended. I'm happy to to say,
Yeah.
but generally inspectors are looking for technical stuff when they go to conferences, and we keep the technical going. But it was boring to do the same stuff over and over again. And
Mhm.
so one year we started a discussion about advanced courses, things that you don't get from online courses generally, from association courses, and not bashing any of them, of course, they're all wonderful, but they tend to, teach to the standards of practice. And we wanted to go way beyond them. and you've helped us do that in a big way. So thank you, Mr. Jon Bolton. See him in Vegas live October 20. What is he? No, September
28th,
20, 28th,
September 28th to October 3rd or 4th
first,
or
first or second, or it
whatever it
just
is.
come to Vegas and stay. It'll work itself out. All
We'll
right,
put it
so
right.
yeah, go to inspectionsuperconference.com/schedule. I bet it says there exactly what day you should be coming. So we we have an ongoing conversation in this industry that is, in my view, an unnecessary conversation, a long conversation, and you've lost something right now there. What are you looking for, John?
I just had what we're about to talk about. I just had it. I think I
Don't
looked
worry,
at.
I'll throw it up on the screen for you.
Oh,
So
I,
you'll be good.
so
Oh, you got a printed copy too. Good. So yeah, of course, what I'm referring to is inspection agreements, home inspection agreements, which I think are absolutely ludicrous. Most of them are written in such a way that they basically say we inspect not a lot, when most of us inspect a lot more than this minimum amount that our inspection agreements say. It takes things like visible mold and excludes them. And like, who sees visible mold? I want to meet the inspector that sees visible mold or something that looks like it and goes, man, I can't say anything about that because my agreement says I don't have to. I don't think that there's too many inspectors like that. But then we get into issues of recourse for the client, and I think it's been an incredibly clumsy thing the way that most inspection agreements read. They say things like, we're only responsible up to the inspection fee, and also, maybe you have to go through arbitration with us, maybe you have to notify us and give us a chance to go and look at things, and that's all good. But they've never really served to solve any issue. Almost every line of an inspection agreement, when the shit hits the fan, serves no other purpose than for lawyers to argue with lawyers at your expense. That's my view of it. It's not an uneducated view. I see it every damn day. I was just talking to somebody this morning that spent $35,000 in legal fees over, yeah, defending who's responsible for what and arguing uh, really contractual issues. I think it's ludicrous. I think we just take care of clients real well, and by take care of them, I mean we pay for the issues that come up, and we do a damn good job of it. But let's put all that aside for a moment and have a little argument about terms and conditions. I have the inspectigators agreement here, and I think this is really good. So I'm going to put it up on the screen. We're going to use it as uh, a conversation piece. So let me find that real quick.
It was actually used one time in court, the only time that we have been sued and gone to court. And I was scared, of course, scared to death that, and because my attorney at the time warned us that it's possible that the judge will side with the consumer regardless of whether you're right or wrong. Doesn't make any difference. And I was
hard to argue with his logic there. That's very true.
Yeah, right. So
Yes.
I was pleasantly surprised when the judge sat there and she never even looked up. She read through the agreement. She flipped the second page back and forth, back and forth. She just kept reading the agreement, and she finally looked up and says, "There's no reason you need to be here. Go to the mediation or arbitration, whatever it was, room next door. Case closed." It was that fast, but it showed that this agreement actually held up in court. So I feel good about that.
Good. Well, and I'm glad that it did for you. And actually, before we get started, this is my view on lawyers and the courts, because your lawyer told you something that it plays out. It does play out. This is not, they were not wrong when they said that the judge might side with the plaintiff, might split babies, just give away some of your money when you walk into the courtroom. And your lawyer's not wrong when he says that. But I want to give you a little bit of my historical experience on this. When I was very early on in the business, I had outside counsel that I would call and take to to court, and they would want to be lawyers. They would want to go in there and make arguments for me and all of that. And 2 or 3 times I walked into a courtroom thinking, I am just dead right. Like, there is no way I'm losing a penny today. And I would go to the courtroom, and then this lawyer would argue with me or for me, and do an okay job, and we'd end up splitting babies. By about the 3rd or 4th time that we went to court, I said, all right, new strategy. You act as if you were born without the ability to speak, and I'm going to take this over, and you're just going to sit there and say, yeah, my client is not even listening to me. He's going doing his own thing.
And as good as I know you, I think those were probably your exact words.
Exactly. So this is like, I don't know, I was 21, but I knew my business, and I knew HVAC systems, and I knew electrical systems, and these people are generally coming after me on the same kind of basis that they do inspectors. Something crappy happened to them that day. A contractor sold them something they didn't need, and now they want to make it your problem. So once I started making the arguments for myself, I never paid out another dime in court. I ended up settling a lot of stuff because you just don't want to go. It's not worth it all the time. And if there's something you did wrong, if there's something one of your people did wrong, you want to make that right as a business owner. I think you feel the same way, right, Jon?
Yes, sir.
Yeah. So, it's pretty rare we go to court without knowing we're in the right. So let's go to this agreement now, and it worked so well for you before, and let's talk about the issues of the day. You brought up a couple of questions earlier. Remind us of.
Well, the first one was, in my original agreement, I have a sentence that says, inspector makes and extends no guarantees or warranties whatsoever, either express, implied, blah, blah, blah. And I'm thinking, well, since we do offer warranties, should I take that word warranties out and just leave inspector makes and extends no guarantees?
Well, you can. I don't have a problem with you taking that word out of there as an exclusion or exception, because you deliver a warranty with every inspection. So, why are you saying in your agreement that you don't? That being said, the warranty obligor the service contract holder is, in your case, Residential Warranty Services Incorporated. So, contractually, Residential Warranty Services is bound to those warranty terms and to offering the warranty. The Inspectigator is not. I think it would be fair to say the Inspectigator is obligated when they're marketing that they include a warranty, that they provide it such. But once they provided it by a qualified provider, and that provider acts well and diligently, then it really makes no difference to me whether it's in your agreement or not. It could be explained either way. And I'll give you the big test here. You've been a client of ours for like a decade, a little bit more than a decade, actually.
Yeah, more than that.
Yeah. And in all that time, and not just hundreds, thousands of clients, and all that time, how many clients have said, well, wait a second, your agreement here says you don't offer a warranty, but there's your warranty.
Yeah, right. Since you provided this new language, which I know you'll get to in a second, I actually went through and started rereading. It's been a while. Nobody sits or at least very few people sit and reread their agreements on a regular basis. And I saw that, and before I took anything out, I wanted to at least go by and clear it with the authority, that being you, and just make sure you were good with that.
I'm good with it either way. I would have a different piece of input for you if, after dealing with, I don't know, 5 or 6 million people, if I had anyone come back, because inspectors have this in their agreement in all sorts of different ways. I have some that will state that they utilize us, some that will say they're not offering a warranty of any kind, some of them that don't even address the issue at all. And I have yet to have a single one where that caused an issue from a legal perspective. So you can't go wrong. Pick one.
Cool. Just wanted to make sure.
Yep.
I had in my old, my original agreement, a reinspection, which is the second page, reinspection time frame of 72 hours. And in the new language you put 5 business days. So those are the two of the things I highlighted on that second page. And again, just wanted to, okay, a little further down. Yep, boom, those two highlighted.
Okay, got it. Okay, so let's go over this first for those that haven't seen this section, the limitation of liability and clients' rights, obligations, and recourse section. So this is a section that's designed to replace all of the typical, inform us in this way and give us X amount of days to go out and check out the issue, and then we'll argue about it, because that's all that language means. Instead, what we've replaced it with, and you can see it on your screen, press pause if you want. In fact, go ahead and do that. Press pause. Okay, we'll wait for them, John. They press pause. So, they'll be back in a minute. They're just, checking it out, maybe taking a screenshot and then keeping it. Hold on, they're back. All right, so hope that was educational for you. You got your screenshot, put it on your hard drive of your computer, and you're going to fix your inspection agreement with this verbiage later. And here's the reason why you should do it, because it says to clients, here's exactly what you do under any given circumstance. Did something new happen? Did something new break? Is it something that's covered by one of the warranties that's provided by the inspection company? Is it, in fact, something that is missed? Okay, well, what do you do, and how long do you have to identify those things? And you won't find, and I won't bore you by like reading it or going through all the points, but you won't find a better worded piece of verbiage for your inspection agreement than what you see on your screen right here. And it should be a section in everybody's inspection agreement. So there you go. Now you have this reinspect out alleged condition within 72 hours of receipt of written notice by client. Okay. And I had the 5 business days. Well, right. I think they're 2 separate issues. So the 5 business days that I had was in the context of, how long you have to respond to an issue. Are you actually going to take 5 business days to respond to an issue? Absolutely not. I've never seen you take 5 days to respond to a client since I've known you. But it gives you contractually the ability to do it, and more importantly, it takes away the ability from the client to go, "Oh, you didn't respond in 2 days. I'm going to do whatever the hell I want to and come, sue your ass for it." So that's what the 5 business days is. Now you have a different issue, which is okay. You've agreed to come out and re-examine whatever it is that they tell you that you allegedly missed. You've agreed to come out and check it out within 72 hours. In my view, it's concurrent. Like during this 5 days, at some point, you acknowledge that there's an issue that might be an inspection miss, or that they've claim something that is, reasonably could be an inspection miss. And at that point, you start your 72-hour clock. I don't think there's too much of a conflict here. I would just make sure that, when somebody comes to you with an issue, that you're there within 3 days.
Okay. I just didn't want, say, an attorney to make an issue of it. Hey, you've got an inconsistency here. The other thing I think you had put in here, okay, yeah. Client is required to inform the inspector within 30 days of the inspection of something they missed. And often, people don't even close within 30 days. So I want to bring that up with you and see if that's something you want to leave it there, or maybe modify within 30 days of inspection, or from
well, you could certainly put that this verbiage was not meant to be one size fits all. It's a one size fits most. I don't think anybody needs to change it much, but you could absolutely put in here within 30 days of inspection, or 20 days after closing, whichever is later. Like you could do that. That would be fine. I wouldn't put 30 days after closing. I'd put 20 days.
Okay, or 20 days after closing.
Correct. In fact, 22 days is an interesting number. If you put 22 days, I think that would be ideal.
I was going to say that next. You want to just make it consistent with something you invented, ages ago?
Well, yeah. So, we have with our 90-day warranty, it's 90 days from date of inspection or 22 days after closing, whichever comes later. Well, if the 22 days in your agreement matches up to that, then it's consistent. At least it's less confusion for the client.
Excellent. All right.
What else? I have to tell you, John, and you are people that are watching this. Okay. If you're looking to choose an inspector in Orlando, I could give you 10,000 reasons, actually like 100,000 reasons to pick Jon Bolton. And so, don't take this contract talk, if you're part of the general public, as something that is, something that is a priority on his mind, because his priority is taking care of you as a client. It just happens to be, if you were in our industry, our little niche industry, that this is a thing we talk about so much, probably way too much. And so Jon was very generous with his time and openness to share this. I'm going to be generous with Jon and tell him to get rid of this arbitration provision. Have you lost your mind?
We got rid of the attorney's fees clause, but the arbitration part, yeah, it's lived in there forever.
Well, I'm dealing with one right now where somebody's saying, I'm forcing you to arbitration. And they don't really know how to respond because they have this arbitration provision. Now,
Right.
Now the good news is that you have this for you now, is that you have this arbitration provision, and it comes in after, all of this stuff about exactly what the client is required to do for every possible scenario. So by the time they come down here and go, well, wait a second, we're just going to arbitrate this. Well, no, you don't have anything to arbitrate. There's no damage to you because we gave you a way to solve your issue. Now, if that doesn't work and you want to go to arbitration, that's fine. But if you're not going to cooperate with the process, then we're not going, and you can sue us. So, um, unfortunately, that creates a situation where, somebody who's just deciding they want to come after you for no reason, which, by the way, in all that time I've known Jon Bolton, uh, he hasn't had many issues. But when somebody does come after him, it's for no fault of his own. It is, just a bad day. A client's having a bad day and something broke, or worse yet, and most commonly, a contractor comes in and tries to sell them something that they don't need on some crazy basis. And when that gets into the thousands of dollars, people are going to take you up on this arbitration thing. I think it's worth getting rid of. I'd just delete the section.
Well, since you've got my back and you were in charge of this process, if you want me to remove it, it will be gone in the next now.
Well, I can't go to arbitration for you, really. Like, what am I going to do at arbitration? Just hang out for the day? No, I'm not interested in that. If somebody has a legitimate issue, which again, I have not seen anyone with a legitimate issue against Jon Bolton or Inspectigator in all our years. We've had many things that we cover. We cover all sorts of things that break, and we do that with a smile on our face. It's called good customer service, and a wonderful product. But I haven't seen anybody come after you to say, "Oh, you treated me wrong," and have any legitimacy to it. So I don't see why we give them the outlet to be this.
That's where the judge would tell us to go anyway, if it ever got there.
Actually, they'd suggest mediation.
Yeah.
Well, mediation's very different. Mediation means, just as an aside here, mediation means you get the two parties in a room, and there's generally a mediator, somebody to go walk. They usually put many miles on their walking path that day, because they go from room to room over and over and tell the one guy to be more reasonable, and we could just get rid of this if everybody did this, and that's their job. They just get to play referee on trying to come to the middle ground of settlement, whatever that might be. But one thing you don't have in mediation that you have in arbitration, particularly in a binding arbitration, is somebody that sits there making a decision. They hear everything from one side, everything from the other. They know nothing about home inspection or real estate or houses, or other than what they've experienced in their life, generally. And they're going to make a judgment at the end of that meeting that is binding on you. And they just say, "Oh, well, I don't really understand this, but it sounds like you owe them a couple $1,000." That was silly. Makes
Agreed.
sense?
Agreed.
So yeah, let's get rid of that. There's just no reason to have it.
It's gone.
And that, other than that, this is a very, very clean inspection agreement. I love it. It doesn't have a bunch of limitations anywhere other than, the standards of practice, which is, of course, set forth in your state under licensing for state of Florida. So congratulations on making something simple and easy for your clients to understand. And I hope more people follow you down that path.
Oh, they have. It's quite an incestuous document. I got it from him and he got it from her, and you know how that goes.
Oh yeah. And that's exactly what happened with all of these documents in home inspection. Just a small little weird industry. So Jon, what parting words, because we got to move on to our next thing here, and start getting ready for Vegas.
Amen. Hey, no, I'm just really thrilled with the new verbiage that you have added. This just spells it out line by line. I'm excited. I'm just so excited to get this in and implemented. So I appreciate all the effort you put into it, because I know that cost you in legal time and all that good stuff. So thank you very much. And absolutely, I can't wait for Vegas. Like who couldn't? Bellagio is going to be, we're going to blow it up.
Absolutely. And it's been too long since we really partied down in Sin City. So come join us. We've missed you. Last time we were there in Palms, we had a record number of people, like 567, I think was our number. I'm not sure that we'll hit that this year, but we're hopeful to see hundreds, and we'll undoubtedly see 200 plus. So come and join your friends. We'll have a good time. John, stop working out. You're making us all look bad, and can't wait to see your courses there. Which, by the way, if you miss them, if you don't make it to Vegas, you can see them live. They do a road show, and in fact, we were just in some city together. I'm trying to think of where it was. Oh yeah, San Diego.
San Diego.
That's right. All right. So look that up on Home Inspection. You have a website, a URL for Home Inspection University Advanced, correct?
It's actually homeinspectionschoolflorida.com.
All right. Head to homeinspectionschoolflorida.com to get more information about those advanced courses and when they're coming to your neck of the woods. Otherwise, we'll see you in Vegas.
Awesome. Thanks, Nathan.
Thank you, John.